Good evening, and welcome to Negotiating Reasonable Accommodations. This webinar and telelearning series is brought to you by Can Do Multiple Sclerosis, the National Multiple Sclerosis Society, and the Multiple Sclerosis Society of Canada. It is the first in a four-part series looking at employment issues and MS. My name is Laura Coyne, and I'm the Programs Manager for Can Do MS. Your moderator this evening is Barbara McKean, the Director of Employment Programs and Services for the New York City, Southern New York chapter of the National MS Society. Can Do MS transforms lives. We deliver educational programs on exercise, nutrition, and symptom management to inspire and motivate long-lasting change for those with MS and their families to help them thrive. Please visit the Can Do MS website, mscando.org, to learn more about Can Do MS's online and nationwide in-person programs. Can Do MS is excited to partner with the National MS Society to bring you 15 webinars in 2017. At this time, I would like to introduce Barbara McKean.
Thank you, Laura. Good evening, everyone. The mission of the National MS Society is to help people affected by MS live their best lives as they stop MS in its tracks, restore what has been lost, and end MS forever. We're pleased to have you join us in tonight's program, and you can explore other society programs, services, resources, and connection opportunities at nationalmssociety.org. The topic for tonight's webinar is negotiating reasonable accommodations. For someone with MS, obtaining an accommodation can sometimes make the difference between being able to continue working or having to stop. However, obtaining an accommodation can sometimes be a very challenging process. The way you approach your employer and what you ask for can make the difference between approval or denial. This evening's program will provide you with information on your right to an accommodation process, and how to negotiate for the best possible outcome. Our speakers for this evening are Nina Martinez and Magda Moncrief. Nina is a Skadden Fellow and a staff attorney at the New York Legal Assistance Group in New York. She developed the Employment Mediation Project at NILAG in order to provide quality mediation services to low and middle income parties embroiled in employment-related disputes ranging from wage and hour issues, discrimination, and accommodation. She also represents parties in the mediation of their employment disputes at the EEOC and in federal court. Ms. Martinez is a graduate of the University of Pennsylvania Law School. During this time, she worked as a law clerk at Make the Road, New York, the Office of the General Counsel of the Equal Employment Opportunity Commission, and the U.S. Department of Labor's Regional Office of the Solicitor. She's currently serving as an adjunct professor at CUNY Law School, supervising student mediators. Magda received her double bachelor's degrees in Human Resource Management and Psychology from King's College in Wilkes-Barre, Pennsylvania, and has her MBA from LaSalle University. She has worked in the human resources field for 10 years. She's a certified professional in human resources and Society for Human Resource Management certified professional. She's been with Iron Hill Brewery for 4.5 years and was a member of the team that was awarded HR Department of the Year in 2014 and was herself nominated for HR Person of the Year in 2016. She also incorporates her knowledge and love of HR and business as an adjunct at LaSalle University and volunteers her time with the Delaware Valley chapter of the National MS Society on topics involving employment. So I will now turn over the program to Magda and Nina. Welcome.
Good evening, everyone. This is Magda Moncrief, and we will be beginning tonight's webinar with a quick poll. So our question is, have you ever requested an accommodation in the workplace? So if you could please let us know by selecting yes or no, just to get some feedback on the experience of our audience. In just another minute or so right now, we have it's about half and half. 51% of you have said that you have not, but 49 said you have. So I'm sure that we have a mixed bag in our audience, and it's nice to know where to start out. So to begin the presentation, we're going to discuss what is the law and what are your rights. So Title I of the Americans with Disabilities Act of 1990, the ADA, which we will reference, requires an employer to provide reasonable accommodation to qualified individuals with disabilities who are employees or applicants for employment, unless to do so would cause undue hardship. The federal law protects you from discrimination and imposes a duty to accommodate. A covered employer must have at least 15 employees, and some cities and states have enhanced protections.
Hi everyone, my name is Nina Martinez, and I'm just going to quickly walk through some of these expanded protections that are kind of touched upon on this PowerPoint. But you know, it depends on the state you're in. For instance, New York covers employers who have 4 or more employees, so that's wider coverage as opposed to that 15 or more employees minimum. But in general, you should be aware that accommodation is just generally any change in the work environment or in the way things are generally done that would enable someone with a disability to enjoy essentially the equal employment opportunities granted to everyone.
I agree. And some things to remember that while the law is the floor of where employers need to begin, some companies may have policies that can be more generous. So those with less than 15 employees may provide the same coverage that those with 15 or more do, despite not being obligated to do so. And others, you know, may just have enhanced policies. So it may depend based on the employer.
So given the requirements of the ADA, the question really becomes, what is the employer's duty? And really the issue here is that an employer should provide an accommodation as long as it's not unduly burdensome. And that means that they don't have to provide the exact request that someone makes if it is unduly burdensome. And we'll get into what that terminology means, but the requirement here for an employer is that they must engage in something called an interactive process, a dialogue with you when you make a request, because the goal is to find a mutually agreeable solution.
And remember here that the interactive dialogue is the key to the process. So even if the end result of a process is the denial of an accommodation request, both the employer and the employee must participate in this dialogue in some way. And we'll talk a little bit about what that may look like, but the interactive process is really essential.
So, like we'd mentioned, the question becomes, what is a reasonable request, and then what is unduly burdensome? And there are a number of factors here, a number of variables that really affect what is reasonable, and it can really vary from workplace to workplace. But some of the indicators are the size of the employer, so how big is the workplace and the employer, the cost of the request you're making, how expensive is the thing you're asking for, the needs of the business. Is it going to just be a totally difficult thing to provide because of what the business needs from its employees, and what the essential duties of that position are.
And you will need to go into detail based on the employer's obligations and limitations. So asking one organization to install an elevator may be extremely difficult compared to a larger organization. And there are some implications when it comes to the FMLA and ADA. So the most recent update to the ADA a few years ago actually requires that you need to consider leaves of absence at the end of FMLA as an accommodation. Whereas before, once someone was done their FMLA leave and you had finished your 12 weeks of unpaid leave, if you could not return, then you could your status could be changed to terminated, and if you couldn't return to work, that was it. Well, now you need to enter into a conversation, and for some organizations, it's feasible to extend that leave further. Others, it's not. So it really does depend on the organization, what their size is, and the cost.
And an important note here also is that you should know that you're not expected to be some kind of, someone that can see into the future and really know the business to know what exactly is burdensome for the employer. The onus and the obligation of showing something is too burdensome to provide as an accommodation is on the employer. And again, it's going to depend on the circumstances and often the budget of your employer. But, so examples a good example is something that might cost, a request that might cost $10,000, for instance, once you kind of quantify it. A small business might just not be able to handle the burden of a $10,000 request. However, a larger business, a kind of massive corporation may be able to do that. And so I think really the goal tonight in thinking about what's burdensome is not so much to predict what an employer can or can't provide, but rather to think about alternatives and be flexible and creative in the request that you make, recognizing the potential limitations of your employer. So really the key takeaway here is that you must still be capable of performing what are called the essential functions of the job with or without the accommodation. And Magda is going to talk a little bit more about that.
So one really important thing that you need to keep in mind is that you cannot remove an essential function from that position permanently. So, some organizations have been really good about this with their job descriptions. They have ADA compliant job descriptions that have already determined what exactly is an essential function and what is not. Other organizations are not as on top of that, but that may be a part of the interactive process. And if your accommodation requires your employer to remove an essential function, you probably cannot move forward. You need to be able to do the job with assistance of that accommodation with all the essential functions intact. And so, Nina and I will both talk about both sides of this, but, an essential duty may be to be present for your job. That's really important to be there, certain core hours or within a certain location. So a leave of absence may not always be feasible or specifically sporadic leave of absence. But, an accommodation provides you with a tool or assistance to do your job. It doesn't change your job.
So to break that down a little bit more, really in layman's terms, an essential function is just what are the basic requirements or basic duties of the job. And I mean, as an attorney, I can give you the example that a lawyer, an essential function, an essential duty of what we do is that we have to be able to research, we have to be able to write legal briefs. But for instance, being present and in the office from 9 to 5 isn't necessarily an essential function of our job. And that's just because you're capable of doing the things you have to do, like research, like writing, away from the office. So it really is going to depend on whether something like regular attendance is necessarily an essential function, but the generally a higher skill work is going to call for a certain degree of independence that allows you to not need to be regularly present. But there are other jobs that necessitate being present, and those include most office jobs or shift jobs where you're expected to answer phones, you're expected to be present, and that includes just a whole series of things. Okay, so we're on to another poll question, and the question is, have you ever received an accommodation that was something other than a leave of absence? We're kind of curious as to, is a leave of absence a go-to request for those who have made an accommodation request, or if people have requested other things? Okay, so it looks like we've got about 61% of people have said no. they haven't asked for anything other than a leave of absence. And we've got a little bit of a combination here. So that's going to be interesting in moving forward in kind of discussing what your various options are. So I think while people tend to think of a leave of absence as, you know, the most obvious choice for a request for an accommodation, there are a whole number of things you can request that the EEOC has said are generally reasonable. And that includes things like making existing facilities accessible, like Magda had mentioned, you know, maybe not necessarily an elevator, but including ramps or something of that nature. Job restricting, so limiting the work that you do. Part-time or modified work schedule, so really kind of working the schedule around when you might suspect you have a flare-up or something of that nature. Acquiring or modifying equipment that, you know, often includes, you know, ergonomic instruments. Changing tests, training materials, or policies, so policies that might have a negative effect on individuals with disabilities might be able to be modified. Providing qualified readers or interpreters, that's generally the case with blind or deaf employees, and reassignment to a vacant position.
Some other examples include you know, a work area closer to a restroom, voice transcribing software to help with typing issues. And one really creative example that I had heard of at a seminar I went to was for an individual who was having some cognitive issues. Actually, he did not have MS, but had cognitive issues nonetheless. And he was an overnight maintenance person, and he could not remember all of his tasks. And so he would be texting his manager at 2 a.m. and 3 a.m. trying to remember all of his duties. And that obviously didn't fly. And so a creative example or a creative accommodation that they came up with was to purchase him a smartphone. And so then with the smartphone, they scheduled reminders and alarms for all of the duties that he was responsible for throughout his shift. So really just being willing to get creative and just to see what exactly you can do and your employer can do to help you get your job done. And now we're just going to walk you through the interactive process of requesting an accommodation. So the first 3 steps for self-assessment is really to self-assess your own limitations and the essential functions necessary to perform the job. So if you already know those essential functions, great. Maybe you can try to assess yourself if they're not clearly defined, what they are, and consider, are there accommodations that work? You know, what has worked in the past? What have you seen, or what are you aware of? Maybe what has worked in previous positions. And recognize that you may need to go on disability or unpaid leave as opposed to an accommodation that functions in the workplace.
So I think generally when I advise clients who are looking to request an accommodation at work, I really urge them to do this kind of what we've called a pre-step or the self-assessment. And really what that entails is to meet with your primary physician or a specialist or whoever it is that really understands your condition and can really kind of sit down and think through various alternatives and think through what is going to make work easier and more doable in the case that, you know, you've been at the same place for X number of years. And really that's just because individuals with multiple sclerosis are experiencing a whole constellation of really complex symptoms, and it's hard for your employer to understand those. But when you've got a doctor, you've got someone who you're working with for a long time who can help kind of make the connection between the condition, the disability, the end, and what needs to be altered at work. I mean, you're going to go into the process a lot more successfully because you've reflected on what's feasible and what's not, and then really stepping back and thinking, well, if what's going to make doing work possible means requesting, you know, a 2-day or 3-day work week, and I'm you know, I'm in a position where the expectation is that I'm there 9 to 5, Monday through Friday. Maybe this isn't going to be an option, and maybe I need to kind of pivot towards thinking about applying for disability or finding a position that can accommodate this by nature of the way the job is.
I agree. And also, you know, that really, that initial consideration of possible solutions that would fit within your organization is really helpful. I know that when I've entered into interactive dialogues and conversations with employees, you know, especially ones that really care about their workplace and want to continue to work, it's obvious that they've thought this through, and many times they come, you know, really prepared, and it's a very short interactive dialogue because they kind of have a solution, and often it really works and it's feasible. So, you know, that's really valuable. And I think it's really, really important and crucial for your doctor to consider any and all accommodation options when completing your paperwork, which we'll talk about in a few slides. But, you know, the last thing you want to do is have your doctor paint you into a corner or do something too specific or not really understand your job. And so I think it's important for you to have that dialogue with your provider as well, so that they understand the possibilities and what really will help you. Because lots of times that paperwork that I get from doctors, it's not much help. And so then, you know, we're kind of on a fishing mission. And so step one, making that initial request. How do you request an accommodation? Is it in writing, you know, super formal, or is it verbally to your supervisor, and obviously a little more informal?
So from a legal perspective, it's generally best to just make a very clear request in writing. However, Magda kind of touched on this in the last slide, but sometimes an employer may fixate on certain things in doctor's note that doesn't necessarily reflect the request. So I think you want to make sure not to kind of a very specific request. I think something very general, broad, just indicating that you have a disability and that you would like an accommodation does the trick. You're initiating the process, and you're not, you know, fixated on one option unless, you know, you've really thought about something that's kind of small in scope and wouldn't require, you know, too much of a back and forth. But really the goal is to just initiate the conversation, because they can't really engage until they know.
I agree, and I really suggest an introductory conversation with your managers or HR, and particularly with that self-assessment part. You know, if you're only having issues with one part of your job, then you don't necessarily have to overshare, and we'll talk about that in a couple of slides as well. But, you know, even with your doctor completing paperwork, you may only need assistance with one task in your position. So, but make sure that if, you know, in that conversation, and it's up to you, it's your preference on how much you share versus keep to yourself. But, you know, if you're uncomfortable with things being shared, I would suggest to make that clear to your employer, because if you overshare to them, they may think that you are sharing that way with others and may speak more openly than you would like. You know, as a rule, the employer should only be sharing minimum necessary information for operations regardless of that. But I think just to protect yourself, you know, if you are uncomfortable or if you haven't disclosed to anyone in the workplace, then you might want to just let them know that you would like to keep it as private or confidential as possible.
So on that same kind of first step, in continuing that question of making the initial step, you know, key thing we're often hearing is, who do you contact? Who do you direct your request to? And, you know, the short answer really is it depends.
I agree, and I joke in my company that, you know, lawyers and HR alike, our favorite answer is it depends, because it really does. We can't give you, you know, an answer without really knowing the facts behind it. So I suggest that if you do have an HR department, the HR department is the best to go to. They're not going to be the people that you interact with in your day-to-day operations, and are really removed from that setting, and they know the law. But many people work in small businesses where there is no HR department, or your office manager is your HR person. So speaking to a manager might work better in those regards. And sometimes you need to go straight to the owner or operator because they know you, they know what your job entails, and they might be a source of support and a champion for you to hire decision makers, or they may be the hired decision maker.
Yeah, so I'm, for the reasons Magda outlined, I agree that going HR is best, but of course it depends because of the size of the employer. Some things to kind of keep in mind is sometimes managers can help advocate and kind of champion your cause, like Magda mentioned, but more often than not, I see that they can make matters worse. And so when you can avoid going to the direct supervisor and going to owner operator or of course HR, I would, just because there's sometimes there's this concern that they feel as though the request is inconveniencing them, or sometimes they'll say this is really a drag on the team, and that's absolutely not what you should be hearing, because there's an obligation to accommodate as long as it's not unduly burdensome. And so from out of the gate, if you're getting kind of a negative response, you want to make sure you're going to someone who's removed.
I agree. And in situations when there is no HR, you have to wonder how your supervisors are trained to respond. And so some organizations are better at this than others. And like Nina mentioned, you may have managers or supervisors that may only see the inconvenience of your request. And in previous organizations I've worked in, we've had to remind managers that they have to look past the really the inconvenience or at face requests, and really consider really how much of an inconvenience their request could be. I know I've had conversations with managers that said, you're saying you can't do this, but 5 other locations have, and really with no effort. So let's think about this again. And then they'll come around and say, oh, you know what? Okay, maybe it isn't as bad as I think. So, it really does depend on the organization, and you need to consider your other options. So do you have an employee assistance program available? And also resources like the MS Society. So use whatever resources you have.
And just as an additional note, when in doubt and you don't really quite have a clear sense of who you should go to, you should check out the policy manual, or in the case that you're in a unionized setting, the collective bargaining agreement, to really get a sense of what is a protocol, so that at least you're following what's kind of set forth. And generally, if there's a policy manual, there is an indication of who you should be going to. So in this step 2 that we kind of discussed, after you've made that initial disclosure and that initial request for an accommodation, you might be asked to share medical documentation, and the caveat is where it's necessary. So when you wonder how much must be disclosed, again, the short answer is it depends.
It sure does, coming from a lawyer in HR. But we request medical documentation almost in every situation, just so that we can understand the full request. And employers often request documentation, and they should also, or I suggest, but not all do this, ask you to sign a release so that your doctor can discuss your condition with your employer. And this is really helpful in those situations when the documentation really isn't that clear. And I've had to call up doctors and nurse practitioners and really talk through, okay, well, you said this, this, and this. Did it take into account, these functions of this person's job? And oftentimes, depending on your position, so I work for a restaurant, right? and many people work in an office setting. So a doctor may be in a different mindset and may not consider either that you work in an office setting or that your job is really labor intensive. Paperwork is most definitely usually requested from employers.
Yeah, and I think the answer really is it depends, because if you're asking for a very minor change, you know, getting off 5 minutes early, you know, once or twice a week, or something so negligible, you don't need the kind of support to justify it sometimes. But other times, more significant requests are going to need some kind of justification in that documentation. Nonetheless, it also depends on the kind of employer you have. You really can't predict how much of an exhaustive record that employer needs. And so I think doing that kind of critical pre-step we discussed is especially valuable at this stage, because you will have gotten your primary doctor or your specialist on board, and they can really get you a letter that is as helpful as possible. And of course, if you have an advocate, if you have an attorney or an outside advocate who non-attorney, they can also kind of help speak to the nuances of what you're asking for. But you want to make sure the language in that doctor's note and whatever they're receiving is really speaking to both the issues of your condition, of your MS, but then also explains the nexus, the connection between your condition and the request you're making. And I always encourage doctors and when you're submitting information to really make a non-exhaustive list of ideas for the employer, because oftentimes doctors note, because there hasn't been that much kind of back and forth with the doctor, we'll just kind of have a, this person needs 2 days off a week, that's it. And it really, it doesn't lend itself to a good back and forth, whereas if you list just a series of things that you've really brainstormed with your doctor that would be suitable accommodations, there's a whole slew of information that you can work with. And I think one kind of final word of caution about sharing medical documentation is that while the employer may ask for this documentation, I urge clients to be vigilant of requests that do feel overbroad or excessive. I mean, sometimes they're asking for, repeatedly asking for the same records or justification of something that's already been shown, or, it's going outside of the scope, like psychiatric records or things that have nothing to do with the stated condition that was presented to the employer. It's not supposed to be a fishing expedition of your entire medical history. The goal is for the employer to understand that what you're asking for is justified and connected to your condition. And so moving on to that next step, and I think the engaging in an interactive dialogue kind of happens simultaneously when the employer is also asking for your documentation. But the conversation doesn't really end when you make that initial request, that step one. You're going back and forth with your employer, and this might take the form of email exchanges, phone calls, meetings. It's not going to be request happens on day one, and on day two the interactive process happens in a kind of meeting wrapped up in a bow, and then on day three the accommodation is granted. It might take a bit longer.
I agree, and the dialogue can, like Nina said, really can look very different depending on the organization, the person, and can take many forms. So like I mentioned, work in a restaurant. We have a lot of a young demographic. And so I actually just wrapped up an ADA accommodation request that was done mostly through text message because a lot of people don't want to pick up the phone anymore. And depending on the accommodation, you may not be able to get to the same location very easily. So, it could be emails, text messages, through, if you have an intranet or a platform for scheduling, with a message area. All of those things can take that shape. It doesn't have to be super formal. Come into the office and meet at a board in a boardroom. So it can have various contexts. But your participation is required. No, I'm sorry.
Yeah. Oh, no. I think I just want to echo that it really is, if you don't come to a resolution at this stage, you shouldn't give up. I think is kind of my word of encouragement here. I think the goal is if both parties are going back and forth and thinking about alternatives in a way that is both mutually agreeable, you're in a better spot. And I think there's somewhat of a realization that has to be accepted by both sides, that it is a compromise and that it might not be ideal for the employer, but the employer has an obligation, and it might not be ideal for the individual that made the request, but you're not entitled to the exact request that you've made, as long as the employer engages in that conversation and makes some effort to the extent that it's reasonable to provide an accommodation.
I agree, and just to piggyback on that, you may be the person, or the employer may be the person that, you challenge each other to be a little more open-minded about it and think a little more creatively. And so depending on the situation, you may have to call on one another to think that way. So the employer could come in with a certain mindset, and you could come in with a certain mindset. And I encourage you both, so you may have to do this with your employer, but, you may have to open that mindset up a little bit. And they may just be thinking no to certain things, and you may be thinking, well, I only want a couple particular things. And really, it's just trying to have that open mind and continuing the conversation.
I think in the same vein as the previous slide, step 3, engaging in the interactive process and the interactive dialogue. What is the length of this dialogue? Short answer, I think you're getting a sense for the theme. It does depend.
Yes. And, and be aware that temporary accommodations may be approved while you are in the interactive dialogue process, or while you're having paperwork filled out from your doctor. And so there have been instances where we have allowed something that seems, very generous from the company standpoint to be a temporary accommodation. And then when we get everything together and we're meeting and having a discussion, we say, okay, well, this is for the length of time you're requesting it, or for whatever you need to get done, this doesn't make sense. Let's talk about some other options. So there may be accommodations that may be temporary, and that once you're in that interactive dialogue process, you'll move along, and you may come up with a more permanent solution for the time frame that you need that can be decided upon. And again, another theme, open communication is recommended.
And as we mentioned earlier, this process may take some time. So day 1, you make the request. Day 3, you receive the accommodation. It's not going to necessarily work that way. And it's really going to be dependent on how complicated the request is, how much of an endeavor is it to provide it, and then also you should be aware that it also depends on your company's procedures. So for instance, public employers, the public school system or city or state government, there are a lot of layers of management and bureaucracy that doesn't necessarily mean that they don't want to provide the accommodation, but there are a lot of kind of people that have to kind of okay, and there's a more formal process in terms of the way they enter it into whatever various systems they have. However, generally, if it's taking many, many months, you want to maybe speak to an outside advocate like Magda mentioned through the MS Society, or an attorney, because there might be some evidence of obstruction in your efforts to gain accommodations. And I don't mean to be doom and gloom, but I think 6, 7, 8 months, depending on the situation, might be an unreasonable time to wait for an accommodation. So step 4, we're talking about memorializing an accommodation, and the question, there's no, it depends on this one. Should you get your accommodation in writing? The short answer is yes.
Agreed. And I actually recommend this from both an employee and an employer standpoint. Many reasons to memorialize an accommodation. A few are, managers come and go. So in my organization, we transfer managers throughout our locations pretty regularly. And you may have something set up with a manager who's no longer in that location. And we want a new manager who's coming in to understand exactly what we agreed upon, so there are no questions or no miscommunications. And you want to avoid repeating the process. If you've agreed to an accommodation that's lasting 6 months and you're 2 months in, you get a new manager and he doesn't understand and wants all new paperwork and a whole new interactive process, if you have that in writing, he won't need that information. He'll have everything he needs. It's beneficial to have a document that survives a change in supervisors. And if you don't receive something in writing from your employer, I suggest that you document what you understand the resolution to be and send them a copy, as well as keep a copy. So even if it's in an email, dear XYZ, based upon our meeting last Thursday, this is my understanding of the accommodation that's in effect right now, as of 3/1 or immediately, and just to make sure that you're clear and there's no miscommunication.
I absolutely agree that you should get whatever is agreed upon in writing. But I think my only caveat is that you want to make sure that you leave it open to change or open to the possibility of revisiting it, just because I often have clients who have gotten an accommodation and then see themselves needing to revisit it a couple years later because symptoms have potentially worsened. And if that's the case, you don't want to be in a position where an employer says, well, I understood this to be kind of where we were at and that was it, and you just don't want to be backed into a corner. I mean, I think generally that's a pretty unreasonable position for an employer to take, but you just want to make sure you take precautions in whatever you memorialized. So finally, I think we want to kind of wrap up with the miscellaneous things that happen and the what's next. After you've gotten that accommodation in writing, you want to make sure to follow up. You want to make sure you update your documentation from your doctor, and you also want to make certain that you understand that the interactive dialogue may be initiated again if accommodations were initially set as something that were temporary.
I agree. And I feel like even if it's not necessarily to change the accommodation, but a check-in should occur with the employer at some point, because I think your employer should care whether or not your accommodations are making sense and helping you. So you want to make sure, both from a supervisory standpoint and from the employee standpoint, that it's working, that you're getting what you need. I have check-ins with my employees with who we have accommodations and make sure that they're getting what they need. And updated documentations may be requested to determine if an accommodation is still needed. So if you have something in effect for 6 months, at the 6-month mark, we may request, hey, how are you feeling? Do you and your doctor feel like this is still needed? And if you say yes, you can say, okay, well, let's verify that with your doctor and just, see. And employers may need to prevent making specific accommodations permanent. So not necessarily something like the equipment that would help you with typing or moving your desk closer to the restroom, but something like a lifting restriction, like in my workplace. If we make something permanent, then that could have implications for the rest of our positions in that area. And so those conversations may be going on as well.
And I think we'll open it up to questions and comments.
Great. Thank you so much, Nina and Magda. That was a lot of really terrific information, and I'm sure we have lots of questions that have been coming in. Just to remind everybody, again, if you have a question, and you haven't asked it yet, please type it in the question box found in your control panel on the right. So let's start with the first question that we have. Would a request to change in travel policy be reasonable? This person indicates that they travel internationally frequently, and I believe the current travel policy to allow for better resting accommodations for longer flights is only allowed for flights over 8 hours. Would 6 to 8 hours be reasonable?
I mean, initially I just say, you know, it depends. I think I mean, and I agree, you know, I don't know exactly what the job function is or what the demands are of the job, but I think that it is most likely something that you can at least discuss and see if it's possible. It doesn't sound outrageous to me.
Yeah, I'm gonna totally agree with that, and I think because you started, you know, you understand what the policy is. It's 8 hours, or I'm assuming 8 hours or more in travel, and you're saying, well, look, if this is a 6 to 8 hour flight, is that something you can consider? I think you're already starting from a place where you're making it very difficult for an employer to say no because you've tempered your request. And so I want to reiterate that the burden is on the employer. The onus is on the employer to say, no, this is unreasonable. And they really need to be able to explain it's unreasonable because, you know, our budget doesn't allow. I mean, that's the point of the going back and forth. And they should be coming back to you with, okay, well, the 6 to 8 hours is not reasonable, but actually we may be able to make sure that you get X accommodation, you know, when you actually arrive, or you can take a break before whatever meeting you're expected to you know, go to.
Great. Thank you for that. So our next question is, what accommodations may be granted, while accommodations may be granted, what are the employer's obligations to provide normal promotion and advancement without consideration for any accommodations?
Do you want me to go ahead, Magda, and maybe you can
Sure.
Kind of perspective?
Absolutely.
Okay. So you know, you're performing your job as you would regularly be doing. But for instance, you know, if you're eligible for bonuses, you know, annually by hitting a certain number, but by virtue of working less, you're not hitting whatever quota for the bonus, the employer isn't obligated to give you the bonus because it goes, you know, it goes with the fact that they can't give you exactly what you request. And so that's not to say that sometimes you make a request for an accommodation, it's no problem and they can grant it, but there are instances where you can't necessarily get the part-time and I mean, I'm just using this as one example, but get the part-time and the bonus pay. So it really depends. But I mean, if you're succeeding, you know, you're excelling, and you are, you know, using, you know, an ergonomics keyboard, and you are not given a promotion, whereas your coworker who is not, you know, making the same numbers or doing or getting as high performance evaluations as you, I mean, that might lend itself to some other issue, and you know, you want to kind of determine what is causing that different treatment.
Great. So it could be potentially a discrimination issue going on if that's the case. Is that what you're saying?
Yes. Sorry. Yeah. So I'm sorry that was not so clear. But I think if you're being treated totally differently, and really you cannot pinpoint what differentiates you, and you surpass your coworker in every other, you know, we generally think about comparators, that would be potentially a factor. So you shouldn't be blocked from promotions or benefits of employment because you're requesting an accommodation, but to the extent that it's an added benefit of the employment, you may not necessarily be entitled to it if the accommodation, you know, keeps you from it. And the best example I can think of is something like a quota bonus.
That makes sense. Great. We have a follow-up question to that. What if you do not trust management, including your manager or director? What if other coworkers complain about your special treatment, which is only what they see?
Well, that should be something that I think that you would be, you should go to your management or HR if you have them available, and make it clear that you're experiencing those things, which could be considered retaliation, even if it's not from your supervisors, if you're experiencing it from your coworkers, and they should address it. But, that could be definitely a bigger issue, and they need to be sensitive to that. And it's tricky when you don't necessarily trust the people that is in your management or are your supervisors. I suggest that you utilize whatever resources you have, whether it be internal or external. Anything additional, Nina?
Well, just one clarifying point. It wouldn't necessarily constitute retaliation, but if your coworkers are making you feel or treating you poorly because you're receiving an accommodation, it might constitute a hostile workplace environment. And so that might generate you would need to speak to an employer, and I'm sure if you listen to the following webinar, I know that one's on discrimination. I'm sure they address the question of hostile workplace environment, but I think it's difficult, but you do have to go to management when your coworkers are treating you differently because you're receiving an accommodation. And if they're not, if they don't assist you, it might necessitate further legal action.
Right, and I suggest that you document any attempts at reaching out to management so that you have it for yourself, whether it be on your own or even an email, Mr. Smith, I want to follow up on the conversation we had on this day regarding this issue. You can even keep referencing it so they know that, you've addressed it more than once. Kind of like when people keep re-forwarding email, like, hey, just following up on this, and you see it's been forwarded 5 times and you're not giving them what they need.
Yeah, absolutely.
Great. So our next question has to do with when the appropriate time is to ask for an accommodation. So if someone's on an interview and they have some kind of assistive device, is this the time that one would need to ask for an accommodation if one needs one, particularly if an employer starts to ask about, the person's disability or what their needs are, what the problem is?
It gets a little bit murky at the point of hire because what happens is when you make the request before being hired and then ultimately possibly don't get the job, it's unclear as to whether not having gotten the job was a result of a lack of qualifications or because there was some kind of discriminatory motive there. And so I don't want to, because I think as Magda and I have said, I hope we're not broken records, but it really all depends on the context and the situation. It's in some cases it makes perfect sense because it's really going to matter the request that you're making and how your schedule works out or how your day-to-day works out. And then in other cases it makes more sense to maybe just make the request afterwards so you can avoid you can avoid kind of a trickier situation of later then trying to determine, well, was it a discriminatory non-hiring? I don't know if Magda, you have more concrete advice for me.
Yeah, I just suggest, if you can hold off, then great. Sometimes it's not always easy if it's something that is obvious. you're walking with a cane and it's something to do with that, but if it's something to do with cognitive ability or, typing or anything like that, then hold off until, orientation, or you're filling out paperwork to have that conversation. But I also suggest that if you're asked if you need any assistance during the interview process, if you need any assistance to complete any of the tasks, that you don't mislead them also at that point. That you say, and you can leave the reason why you need assistance, but you can do it very generally and kind of try not to leave too much. And I know there are some resources out there that actually can assist with answering those questions. I know I've done some things with the MS Society that have provided some guidance on that. So if you need any potential assistance with answering those type of questions, there are some resources out there on the MS website that could help.
Yeah, and I think it goes back to that question of the essential functions of the job, right? If you're applying for a job that you can do, but it's a logistical question of where is it going to be located? Am I going to have to go up and down the stairs? Can I take, a half day to recoup after, a flare-up or something like that? I think that's something to preserve for after, because you don't want to suggest you can't do what the job essentially calls for unless it's the case that the basic requirements of the job are going to need to be altered for you.
Good point. Agreed. Good point. Thank you both. So what about the accommodations such as FMLA and the backlash of taking such leave and then coming back on the job or to a vacant position? Is it a good idea?
You mean to another similar, I'm assuming it's another similar position?
That's what it sounds like.
Yeah. Go ahead, Nina, if you had something.
Well, I'm just not quite sure what is meant by backlash, but if you're being treated negatively, or your treatment in the workplace, it changes dramatically after returning from FMLA, the law explicitly protects you from retaliation, meaning that if you've taken FMLA and now, okay, you've come back to the same position, but your employer is not giving you, high-level, jobs that he or she used to give you, that might constitute retaliation. So I think I'd need more clarification on backlash, but know that you're protected against retaliation when you take FMLA leave.
Mm-hmm. Great. Now, is there a time limit for filing a civil case in workplace discrimination? This individual was harassed and forced out of their job 8 years ago, and they were in. It was a Missouri employer, but the person worked in Colorado at the time. I think I'll just maybe go a little beyond what we're talking about this evening, but
I've got that. So I cannot speak to Missouri or Colorado law because it depends. In a state where you have a state agency that is a parallel of the Equal Employment Opportunity Commission. So, for instance, in New York, we have the New York State Human Rights Division. You have 300 days to make a claim. However, when you don't have that parallel state agency, you have 180 days, and that's 180 or 300 days of the harm. So, of the day that you were terminated, in this case harassed, the most recent incident, you have 300 days to file a complaint or at the EEOC, or if Colorado, it's working in Colorado, has a state agency, then 300 days, if not 180.
Great. Great. So what if the accommodation the employer gives you is not the one you needed? Is that considered a valid attempt?
Well, I mean, I don't know what kind of interactive dialogue occurred with that, and if you agreed to that accommodation, and maybe it was a trial, or see how it goes. But if you have an accommodation and it's not working out, then I think you need to go back and re-engage in the interactive dialogue. And just make sure that you're assessing for yourself that, Nina and I both touched on, the accommodation that you request is not what the employer has to give. So even if you want to work from home 3 days a week, that it does not have to be the only option. But if the accommodation itself is not actually assisting you to do your job, then you need to re-engage and, either revisit the process or start a new one.
Okay, great. Is it necessary to state a diagnosis to the manager?
No. So with FMLA, they can only ask particular questions when you go out on FMLA leave. In ADA, you can ask more questions. And so that's something, if you don't want to declare your diagnosis or your condition to your employer, you just let them know what you're having issues with. You don't have to say why. Or you could even say, with MS, just say something neurological, autoimmune. You could just be very vague. And then just communicate that to your doctor as well. So, they could write autoimmune or neurological or even cognitive issues. Whatever the paperwork asks, they don't have to be that specific. They can answer around the question if you want it to remain, if you want to kind of not disclose.
And I think also it's worth adding that you wouldn't necessarily, I guess it depends. If you have an HR, you can, ask for some kind of firewall or some kind of confidentiality, so that you're disclosing to HR for the purposes of them giving you the most, carefully crafted accommodation, but your manager doesn't necessarily have to know, your direct supervisor doesn't necessarily have to know. I do also caveat, however, that you may ask for confidentiality, but that it's my understanding that they're not bound to keep it confidential. If for some reason it necessitates letting your manager or supervisor know, they might, but you can, caution them to use discretion, to really limit what they're saying. But I've had multiple instances where someone says, I thought it was confidential, I thought I was only telling HR, and here my manager also knows. There's nothing really in violation of the law there.
Right, and some organizations are much better with confidentiality than others, and different situations will come up where maybe the individual who had the confidential information felt like maybe the manager or supervisor would get it a little more if they knew, or understood the full scope of it, instead of just thinking it was one issue that it bundled a few. So who knows, but you don't necessarily have to fully disclose.
Great. Okay, next question. If you can't work a full day schedule and the employer offers you a reduced schedule with reduced pay as an accommodation, are you obligated to take that position?
Well, it depends what condition or issue that it's helping you accommodate. So
maybe fatigue. Maybe fatigue.
So,
yeah.
Right. I would assume fatigue.
Yeah.
But ultimately, if that's what you asked for, and that's what was provided, oftentimes when people ask, even if they're salaried, if you go from full-time to a part-time position, then you become hourly. So if that's not what you desire, then you can re-engage in the interactive process and look for other potential solutions.
Okay. Next question. I'm a teacher and would like to know if a leave of absence as an accommodation would have to start and end at semesters as per the contract.
So it's teacher is one of those examples where it's a little bit tricky, right? Because you've got, you know, the set schedule is in part an essential function of what you do. Now, to the extent that your school has, you know, a good kind of setup in terms of, you know, a number of subs or, you know, fill-in time, that it's not an unreasonable thing, it's doable. Now, if you're referring to a union contract, it really is going to depend on the collective bargaining agreement and the language in that. But oftentimes, collective bargaining agreements do have language that say none of the restrictions or the provisions in the collective bargaining agreement should limit, you know, things like requests for accommodation. So you should look for language, you know, that you can point to your employer and say, look, I know the contract says I need to be here from this time to this time, but that's kind of the floor, and I can go above and beyond that.
Okay, great. Okay, we may have time for maybe one or two more. So the next question asks, have you had any cases that an accommodation was made for productivity? I was told they could not accommodate that as it would hurt the company and the job needed to meet certain quota.
I mean, I can answer to some degree that, you know, again, it may depend, but I mean, there may even be times when perhaps that they can grant it versus that it couldn't be granted, depending on the business needs and how the busy season. But also, you know, I don't know if, I mean, they need to show you why. I mean, they need to show that it's a burden, the undue hardship on why. So they can't just say that. They have to actually explain it. I mean, do you agree, Nina?
Yeah, you can't just they can't just give you a blanket no because of productivity, right? They need to, you know, they need to kind of give you some kind of justification, or at the very least say, okay, well, you know, I think we can think through other ideas, and that's where I think you can be your own advocate and saying, okay, well, why don't we approach this from a different angle, and see if we can modify the workplace so that productivity isn't necessarily affected.
Mm-hmm.
Okay. Does the ADA say something about that, though, in terms of an employer not having to make accommodations for productivity?
I can't think of specific like a specific exemption for productivity. Maybe like you know, piecemeal type work. Sometimes there's just no way. But without knowing enough about what is meant by productivity, is that like a sales quota, or is that literally factory work you have to make?
Assembly, right? Mm-hmm.
Yeah.
Good point. It depends, right?
Right.
So let's go to this question. For someone with MS but without visible symptoms, so they have no choice but to disclose their condition to their employer, do you recommend disclosing the MS diagnosis before any accommodation is necessary?
So my personal stance is, again, it depends. For some people and in some organizations, it doesn't make sense, and it could kind of, people feel like it puts a target on them. I have spoken to other individuals who feel like, you know, after they get a certain amount of time in their organization under their belt and they have a track record, that they want to have that conversation with their supervisor or manager, so that the first time they're discussing it isn't when they're requesting an accommodation. I have heard of instances where this has worked out beautifully and created a really great relationship where their managers became supportive, and because that they had worked with the person for a period of time, they recognized that they were hard workers and were prepared that if anything did happen, they kind of already talked about potential accommodations if XYZ happens and how they would work around it. But others feel completely uncomfortable with it. And depending on or the organization you're with, you know, they feel especially uncomfortable. So I feel like it's a case-by-case, a personal choice. But Nina may go against it because she is in legal. So,
no, Magda, I think you hit the nail on the head. I completely agree. It really is case by case, and really feeling out, you know, is it going to be a productive choice to share? And it's really hard to know unless you've gotten a sense of how your employers, you know, what their protocol is for these kind of things is.
Okay, great. Well, great, guys. I think we're really running out of time. We have a few little wrap-up things to do, but I want to thank you both for terrific information. I hope people went away with more information about accommodations and know exactly what they need to do now if they do need to ask for one. We are going to give you information if we didn't answer your question this evening on what to do, so I'm going to now pass it back over to Laura.
Terrific. I would, excuse me, I would also like to thank Magda and Nina, as well as thanking Barbara. You guys did a terrific job and provided some really informative information. As a wrap-up, I would like to inform you of some additional resources that you might find helpful. On the Can Do MS website, which is mscando.org, you'll find our archived webinars, our e-news, and our library articles. You can also submit questions to the Ask the Can Do team, which will be answered by our team of MS experts. If you missed any of this presentation, it will be archived on the website by the end of the day tomorrow.
Great. Thanks, Laura. And I just wanted to highlight some of the National MS Society's resources dealing with employment. We have a variety of employment brochures, including Win-Win Approach to Reasonable Accommodation, so very appropriate to this evening's topic. Employment Matters, which is comprised of video segments about key employment issues, and a toolkit on job searching. The website listed here at nationalmssociety.org/employment is full of employment information, including disclosure, accommodations, and resources on various other employment topics. And I would also like to highlight a website dedicated to our topic for this evening, the Job Accommodation Network, otherwise known as JAN, which is the leading source of free expert and confidential guidance on workplace accommodations and disability employment issues. JAN's trusted consultants offer one-on-one guidance on workplace accommodations, the ADA, Americans with Disabilities Act, and related legislation. Assistance is available both over the phone and online, and you'll see a telephone number there. And also, as mentioned earlier, we'll be sending out the handout which has links to the Job Accommodation Network and other resources related to tonight's program. Now, if we didn't get to your question this evening, on the next slide, we have an email, employmentquestions@nmss.org, or you could call 1-800-344-4867, and we will follow up with you on any questions that did not get responded to this evening, or if you think of something else. On that note, I'll pass it back to Laura.
Terrific. Thank you so much. And the next presentation in our webinar and telelearning series will be on Tuesday, February 28th at the same time, 8 p.m. Eastern Time, Discrimination on the Job. This is the second in our four-part employment series. And as always, you can register for the webinar and telelearning series free of charge on the Can Do MS website, which is mscando.org. For those of you that are participating tonight, you will see a survey appear on your computer screen. And I would ask you to take a moment to complete the survey and share your input. Your feedback is really helpful, and it helps us to continue to improve our webinar and telelearning series. You will also receive a PDF copy of tonight's slides by email. I do want to thank you, and before I conclude, I would like to ask that if you would like to support our webinars with a donation, you can do that by texting 970-626-6232. Thank you, and have a great evening.